Hi, everyone. Thank you so much for joining us this afternoon. I can see that we have quite a few people on the call already or joining already, and people still rolling in here. My name is Carolyn, and I work on the communications team here at Ecojustice. And together with my colleague Jess, I'm going to be working mostly behind the scenes today to help run today's conversation. And I'm calling in from my home office slash kitchen in Vancouver. And I'd like to begin by acknowledging that I live and work on the unceded and ancestral territories of the Musqueam, the Squamish, and the Tsleil-Waututh nations. And in just a moment, my colleague Margot Venton is going to be coming online. Margot leads Ecojustice's nature team, and she's also one of our senior litigators, and she's going to be moderating today's conversation. But before we get started, and to create an inclusive space, I just want to make sure everyone's comfortable using this online platform, especially those folks who maybe haven't used GoToWebinar before. So on the right of your screen, you'll see an image of the control panel, and I'll go over a couple of features here, starting with the grab tab. It's the arrow in the orange rectangle, and when you click on it, it's either going to minimize or expand that control panel for you. With it expanded, you'll see you've got some audio options, computer or phone call. And if you click on the circle beside your preferred audio option, that'll switch between the two. And so this is where you'll find information to call in by phone if that's what you'd like to do today. And then finally, I'll just go over the question box. So you can use the question box to submit your comments and questions at any point during today's conversation. We have set aside some time at the end for a question and answer period. And actually, I know a few of you have already sent in some questions by email, so thank you for that. And I encourage everyone, if you have a question that comes up for you, just send it in to me as your questions arise. And just so you know, whatever you submit using that question box, it actually can't be seen by other participants or our panelists. So I'll be forwarding your questions along to our speakers today. So why don't we go ahead and test out that feature? Maybe if you want to tell me where you're calling in from. I know we've got people joining us from all over the country and from a lot of diverse professions, industries. I imagine some of you are students. Okay, yeah, I see we've got folks from Ottawa, someone from Kimberley, BC, hello, Kingston, Ontario, Halifax, Edmonton, Victoria, St. Anne, Manitoba. Yeah, so we really do have people from across the country, and welcome to all of you. Welcome to the folks from Montreal. So yeah, I'd like to invite Margot to hop on the line right now, and I'm going to turn things over to her.
Hi, Carolyn.
Hello. Thanks, Margot. I'm going to hand it off to you.
Okay, great. Good afternoon, everyone. I think it is now noon in British Columbia, so we are now officially all in at least the same part of the day. As Carolyn mentioned, my name is Margot Venton, and I'm joining you today from my home office on Pender Island in British Columbia. So for those of you not well-versed in the geography of obscure coastal islands, Pender Island is located in the Salish Sea, within the traditional territory of several coastal First Nations, including both Tsimshian and Hul'qumi'num speaking people. The Tsimshian term, or the Tsimshian speaking people refer to North Pender Island as Sideus, which means wind drying, referring to the wind drying of salmon. So for those of you who are new to Ecojustice, I'm going to tell you a little bit about us. Ecojustice is Canada's largest environmental law charity. Our team is spread across 5 offices in Vancouver, Calgary, Toronto, Ottawa, and Halifax. And right now, due to COVID, we're even more dispersed. The Ecojustice mission is to go to court, to use the power of the law to defend nature, combat the climate crisis, and fight for a right for a healthy environment for all. We work with a large range of clients. They range from well-recognized organizations to Indigenous communities, local small communities, and everyday Canadians. And we focus primarily on strategic cases that have the potential to set precedents and redefine how environmental laws are applied and enforced in Canada. And thanks to our generous supporters, we represent every one of our clients free of charge. We do not charge for our legal services. So going to court is hard work, but it's often what is required to ensure that our communities and the climate and the environment are protected by the full weight of the law. And right now, we're particularly focused on the limited window we have to address the climate emergency. That urgency seems pretty real to me today, as normally mid-September, the view from my window would be blue skies, bright sunshine, and I'd be wondering about when I would next get out for a walk or a swim. But instead, for the last several days, the sun here has been almost entirely obscured by smoke from wildfires burning to the south, and we have been advised for the last several days to shelter in place and not go outside if we can avoid it due to dangerously poor air quality. So all of this is really why all of these real impacts we're feeling today is why Ecojustice is committed to holding governments at all levels to account when they fail to deliver, or in the situation of the case we're going to discuss today, when they're attempting to block the climate action we so urgently need. And that brings us to today's conversation with Amir Adaran and Joshua Ginsberg, who are two Ecojustice lawyers who are going to talk to us about the upcoming Supreme Court hearing that will decide the fate of the Greenhouse Gas Pollution Pricing Act and potentially the future of climate action in Canada. Amir Adaran is an Ecojustice lawyer representing the Athabasca Chippewan First Nation on this matter. And something I can tell you about Amir is that in addition to working at Ecojustice, he's a professor at the University of Ottawa, and he's actually cross-appointed to both the law school and the School of Epidemiology and Public Health. Amir is trained as both a lawyer and a scientist with a PhD in biology and immunology, and he brings that dual perspective of science and law to all his work at Ecojustice. Josh is the lawyer working for the David Suzuki Foundation in this matter, and Josh is the director of the Environmental Law Clinic at the University of Ottawa, and where he teaches and mentors students working on Ecojustice cases. So I'd like to welcome Amir and Josh. Thanks both of you for joining us today from Ottawa or nearby, as I understand it.
Thanks very much, Margot, for that wonderful introduction. And before we get started today, I would like to acknowledge that both Amir and I live and work in Ottawa, which is the traditional and unceded territory of the Algonquin people. I'm very grateful to live and work in that wonderful place. And I would also like to acknowledge that I'm speaking to you today from Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is also covered by Treaty 13 with the Mississaugas of the Credit. And I'm very grateful to be here on those territories.
Awesome. Well, thanks again to both of you. I'm going to kick this off with a question for Amir, and I'm wondering, Amir, just to lay the foundation for our chat today, can you get us up to speed on this case? What's it about, and how did we get all the way to the Supreme Court? Can't hear you.
And they deal with the same thing. These three cases come from Saskatchewan, from Ontario, and Alberta. All three of those provinces have sued to stop the federal government putting a price on greenhouse gas emissions, carbon dioxide, methane, various other gases of that kind that warm the climate. We are in this place because, as you probably know, about 2 years ago, the federal government set a minimum carbon price across the country. It's reflected in most places today when you pay for fuel or when industries consume fuel and emit. That price has not sat well with all the provinces. And so in 3 separate challenges, first Saskatchewan, then Ontario, and last Alberta, took it to their courts of appeal, contending that the carbon price is unconstitutional, is outside the power of the federal government. What happened is that in Saskatchewan, that argument failed and the law was found to be constitutional in full. Likewise, in Ontario, it failed. The law was constitutional in full. The only exception is Alberta, and that's because of, shall we say, the unique features of the Alberta economy. All 3 cases will now be heard by the Supreme Court next week together, and that will be the final hearing on the matter, and we are extremely optimistic for a good outcome.
All right, well, thanks for that. Just one follow-up question. You know, it's interesting, this whole, you explained a little bit, unconstitutional means that a law is outside the power of a government. It's not suggesting, so there's nothing in the case suggesting the carbon price is a bad idea or that it's ineffective, but it's a question of whether the federal government has the power to force the provinces to follow this rule. And my understanding is that the Supreme Court has already confirmed that the federal government has the power to protect, to regulate, to protect the environment on a number of occasions. So I'm wondering, is this just the provinces stalling?
Well, Margot, that's basically right. Anyone who's Canadian knows that the constant feature of our country is a tug of war between the provinces and the federal government, not just over carbon pricing, but over nearly anything else. And in this particular case, we have 3 provinces who are saying, no, the federal government doesn't have the power to put a price on carbon. They're saying that only they would have that power.
Mm-hmm.
But they're not in any way supported unanimously. British Columbia has intervened on the side of the federal government. We are aligned with British Columbia, which argues that yes, the federal government can price carbon if it wishes. That's our point of view. And of course, it is a bedrock principle of the Canadian Constitution that oftentimes power is shared between levels of government. So it can easily be that the federal government sets a minimum price for carbon. That's what the law does. It sets a minimum price and then leave it up to the provinces individually to decide how they will put that price into action. Will they do it through a taxation model? Will they do it through a cap and trade model? That's up to them. They can even go further and do things beyond the price if they wish. There's no argument which supports that the provincial governments are out of the picture just because the federal government is in the picture. And I think we all agree climate change is a challenge. It requires all hands on deck.
Right, makes sense to me. So Josh, I'm wondering, like, if you could explain why Ecojustice is involved in this case, and maybe more importantly, why everyone in Canada should really care about this legal fight.
So it's an important question, Margot, because this is not some arcane point of constitutional law that only academics and lawyers and judges are concerned about. This has to do with the stability of our climate and really the safety of Canadians and of Canada. You know, we know that we have only 10 years to make deep cuts in our emissions in order to avoid the worst impacts of climate change. That is the international consensus. And when I say the worst impacts, what I mean is the unavoidable and inextricable melting of the Greenland ice cap, such that our coastal cities are at risk of being overwhelmed and flooded. In addition to the increase in wildfires and heating of the kind that the West Coast is already experiencing, and as bad as that is now, it is on track to get worse if we don't increase our ambition and if we don't act together. So this is about the ability of Canadians to take collective action to forestall a climate disaster. And if that sounds dramatic, it's because it kind of is. It is a really urgent problem. It rises to the level, we say, and our client says, of a constitutional emergency. And that is the argument that we are urging at the Supreme Court.
Yeah, and Josh, certainly watching what's unfolding south of the border and seeing its impact here in British Columbia this week. You've got leaders all up and down the coast and into the Midwest saying this is unquestionably evidence of climate change, the scale of these fires, the intensity of the fires, the circumstances that are causing them to come on faster and be harder to fight. And so I'm wondering what your opinion is, because I think, largely we're at a place where many people and leaders are accepting the relationship, like the real-time experience of climate impacts are happening now, and they're accepting that it's real. But we hear a lot of discussion about carbon pricing and how potentially horrible it could be for the economy. At least you're hearing a lot of that in Canada. And I'm wondering, is there any evidence that carbon pricing does destroy the economy in your research and your understanding?
There's not, and I have to say I'm lucky to represent an organization like the David Suzuki Foundation, which has spent a long time gathering the data and running the numbers as to what the impact is, and the answer is no. It is not an economy destroying measure. In fact, it can stimulate other economic activity, part of the green recovery. That's the kind of economic move we actually need to both stimulate the economy and fight climate change. And as we discovered looking at the evidence, you ask about the evidence in the case, it's very clear that evidence shows that there has been no impact, and Alberta has admitted it. Amir has made some submissions about that. I'm sure he'll have more to say, but the evidence in this case is that there is no impact, no negative impact whatsoever on any provincial economy. So it's not a case of balancing economic harm against environmental protection. It's about doing an obvious thing that will help us avert the worst of this crisis and recover the economy.
Yeah,
Margo,
that sounds pretty
add a
important.
little
I
bit
was
to
going to
that.
say, Amir, do you have anything to add to that? It sounds like you do.
I do. Thanks, Margo. Josh mentioned the point, and I really want to drive it home. There is not evidence in these three cases going up to the Supreme Court that the provinces are going to be economically wrecked by a carbon price. And I cannot emphasize how important that is. The provinces threw a lot of money and effort at this fight. Ontario alone said they would spend $30 million to go to court and try and stop the federal carbon price. So they had the money to put in whatever research, whatever evidence they wanted. And let me tell you what the evidence says. Alberta, the most oil and gas dependent of those three provinces, put in evidence about what the economic effect of the federal carbon price would be on their overall economy and their oil and gas industry. And do you know what that evidence says? That evidence, Alberta's own evidence before the court, shows that with the federal carbon price, the growth of the oil and gas sector economically will go up. It will go up by not much, 0.02% in growth, but that's adding to whatever the growth of the industry would be. It's plus. It's not red ink, it's black. And that's Alberta's own evidence. So if there were strong evidence that the carbon price would be devastating the economy. These three provinces had the chance to put it forward, and they couldn't. They just couldn't.
And so, I mean, it sounds like we've got strong evidence everyone is accepting that that not only is climate change a threat, but it's a threat that's already coming to pass. We're experiencing the impacts of climate change on the ground right now in North America. Carbon pricing won't harm our economies. And I don't know, is an issue in the case that carbon pricing could be effective in actually addressing greenhouse gas emissions? I mean, is that the experience of places where they've tried this? I don't know, either of you guys want to answer that? I didn't ask someone specifically.
That is the clear consensus of economic research that has been done. It is a clear demonstration, for instance, from Australia, where a former government did introduce a carbon price, and then a subsequent government repealed it. And what happened over that period was not economic ruin. In fact, Australia kept growing economically very nicely through that period, but it did make a difference to emissions, which flattened out. And then once the price was repealed, the emissions went up again. So that right there is the clearest natural experiment you can point to, but there's an abundance of evidence from all sorts of academic economists, the World Bank, economists commissioned by the Government of Canada, Canada's own Eco-Fiscal Commission, you name it. And it really is very clear that pricing carbon is a tremendously powerful tool to bring emissions down. And by the way, the provinces do not contest that.
Okay. So switching gears a little bit, Amir, I'm wondering, I understand you're representing the Athabasca Chippewan First Nation on this matter. And I'm wondering if you could share with the people who've called in today what their unique concerns are in this issue.
That part's a bit heartbreaking, Margot.
Yeah.
The Athabasca Chippewan First Nation has lived in its homeland, mainly in the north of Alberta, close to the oil sands, for about 7,000 years, perhaps longer. That is their home. And inside that home, which is a harsh environment, very cold in the winter, prone to floods in the summer because it's at the Peace Athabasca Delta, it's a place that would kill most of us. They've learned how to survive for thousands of years by working with the local ecology, hunting with the seasons, fishing with the seasons, gathering, trapping, all the things that they do, they've learned to do in that setting. And that setting is being destroyed by climate change as we speak. Many of you will have heard that, for instance, climate change will increase temperatures where you live by a degree or two. In northern Alberta, on the Athabasca Chippewan First Nations homeland, the scientific estimate is that temperatures could go up 7 degrees. 7 degrees before the end of the century. That's huge. That's like taking their entire ecology, putting it into a steamer basket. To give you a scale of how to appreciate this, that difference of 7 degrees is the difference in average temperature between Vancouver and Mexico City. That's how great of a difference it is. If that happens, then the survival of these people after thousands of years is in serious doubt. Their traditional ways of living are in serious doubt. Their connection to the modern world as well. Their only land connection is on an ice road, a winter road that opens for a few weeks or at best a month or so in the winter. Well, this last year it didn't work so well. It is an existential question for these people, what happens with climate change, and I'm enormously proud to be representing them.
Awesome. Thanks, Amir. And Josh, you are representing the David Suzuki Foundation, a large environmental organization. And I'm wondering if you could share with us a little bit what DSF's perspective will be before the court, and also how you find working and collaborating with the Athabasca Chippewan First Nation, like how you two approach ensuring what you're doing together.
Yes. Yeah, as I already mentioned briefly, DSF has been doing really groundbreaking, pioneering work over the past decades, really, which has shown pretty definitively that carbon pricing is a necessary, if not sufficient, condition for us to beat back the climate crisis. And to have a group who, is one of the undisputed experts on this topic behind us here means a lot. And they also know that in order to be effective, that pricing has to come in on a very urgent basis. It's really most effective in the short term. And that is also the message we've gotten from the international scientific community, that it's the next decade that we really need to jumpstart our efforts. And carbon pricing is an important part of that. So the combination of those things means that the David Suzuki Foundation's perspective is that carbon pricing is a response to a national emergency, which is that unless we get it right really, really soon, we're locking ourselves into disastrous impacts. And so that's why we say that this particular enactment is supported by the constitutional power of Parliament to address a great emergency. We've seen this used in other contexts. We've seen it used in both of the world wars, where the lives of Canadian citizens were imperiled, and we've also seen it used in the 1970s to combat inflation. So we say if those situations were emergencies and justified the invocation of the federal emergency power, then this crisis surely does as well. And there are safeguards built into the test to make sure that this is not federal power run amok. And so I think it's my job to communicate to the court, first of all, the gravity of this emergency, and to draw the link between the immediate need to get our emissions under control and the provisions of this act, which do just that. And that makes it emergency legislation calibrated to deal with an acute crisis.
Awesome, thanks. So switching gears a little bit, I'm just wondering if you could tell the folks who've joined us, like what it's like to prepare to go before the Supreme Court of Canada. What does a day in your life look like in preparation, especially now that it's basically about a week away? Josh, do you want to go first?
Sure, I'm happy to do that. Yeah.
All right.
So we only get 5 minutes as interveners to prepare to present to the Supreme Court, but the amount of time and effort that goes into that 5 minutes is huge. I forget which wit, maybe it was Mark Twain, who said, I didn't have the time to be brief, to write you a shorter letter or something. Well, that really obtains here. In order to be effective in 5 minutes, you have got to choose every word with great care and to make sure that you have at your fingertips anything that the court may want to take you to so you can be helpful and effective. There are a lot of interveners in the case, and that's great. I mean, most of them are on the side of supporting carbon pricing, and it's great to see civil society, academics, other scientists, First Nations come out in such numbers to say this is important and this must be maintained. But of course, everyone just gets that little capsule of time. So preparation means poring over the evidence, poring over the cases, and making sure that you are presenting the nugget, the core that is going to get that critical point across, especially because it's a perspective that not very many other people are bringing to the table. Although I'm happy to say that having made this emergency argument before 3 provincial courts of appeal, we are now joined at the Supreme Court by others who are echoing this refrain that the immediate climate crisis does constitute an emergency, and this legislation should be upheld on that basis. So I'm very optimistic, but I'm doing nothing else this week but delving into this and making sure that I'm ready.
Right, time trials every day. So Amir, what do you think is about to happen at the Supreme Court hearings? Like, if you, I realize that, you know, this is a bit of crystal ball gazing, but what do you think?
I think we're the very, very strong favorite to win, to be honest. I mean, it's certainly not going to be denied by anyone, hasn't been denied by the three provinces challenging, that the climate realities today have reached a crisis point, and that we are at a point in human history that is unprecedented in the history of the Earth, that really, you know, the last time carbon levels were where they are now was before humans existed. So this is a very special moment. It calls on the court to think wisely about the way it interprets the law before it. You don't hear the provinces challenging, saying that the climate crisis can be ignored. They don't say that. They don't say that it's appropriate to take no action. They don't say that pricing is ineffective. All they argue is that it is outside the Constitution's assignment of roles for the federal government to do the pricing. And that, we feel, is a weak argument. Well, not only has it lost twice out of 3 times, but when you read the dissenting reasons, they simply aren't as compelling. The federal government has a role in this country to set a minimum that defines and builds our country. And that's what this law does. It sets a minimum carbon price. If provinces want to exceed it, they're welcome to exceed it. But having a minimum standard as a matter of national unity and as a matter of what's called to lawyers national concern under the Constitution seems to me a very strong, almost unassailable argument. I have very little doubt this will go well for us.
Okay, well, I'm gonna trust your good instincts in this, Amir, and thus I will ask Josh, what do you think a victory in this case would mean for climate action in Canada?
So a victory would mean confirming what, you know, we hope is pretty clear, that in order to be effective in meeting the challenge before us, we need national action. And it's not good enough to have a patchwork of attempts, some of which just aren't good enough to get us where we need to be. That in fact, this is a collective action problem and demands a collective solution. And so the clear message is, yes, there has to be one unified response, but all levels of government have a role to play. The role of the federal government is setting a minimum standard. And within that, there is lots of room for the provinces to exercise all of their jurisdictional tools to help in this effort. The Greenhouse Gas Pollution Pricing Act doesn't take anything away from any province. It doesn't impinge on their ability to do anything. It just says, here's the floor, and meet this in the way that you find to be effective and expedient for your circumstances.
Okay, and I'm wondering if either of you have an opinion about whether it's possible that a decision from the court could actually end some of what appears to be kind of political barrier creating on the parts of the provinces. Like, is it possible for us to get beyond this fight about who's going to do something, just get to the place of actually acting, and maybe what all of our role collectively could be in encouraging that political action to just be like, okay, fine, we're doing this.
Yeah.
Let's get going.
I certainly hope the judgment puts to rest some of the over politicization of this issue. I mean, it's shocking that there's so much politics is played with really our future and even our survival. And so if it puts an end to that, or reduces it, that will be an important victory.
And I want to second that. I mean, there's a great deal of denial, or its close cousin, avoidance of climate change. And it is political, it is ideological, it's dangerous. You know, if one were to imagine a political movement that denied the existence of COVID, it would not have a long life. And yet, what we're facing is something that can be just as devastating as a pandemic. Yet it's turned into a political football. There's a great deal of showboating around it. This has to end. It simply has to end. And I think that the role of the courts writ large, if you look at how courts fit into society, courts legitimize or delegitimize certain points of view by their judgment. I think we are going to have the benefit, after the Supreme Court's wise analysis, of somewhat delegitimizing the point of view that climate change exists, but we don't need, as a nation, concertedly to do anything about it. That notion will be dealt a hammer blow if we are successful at the Supreme Court.
Okay. That would be great. And so I think we have a little bit of time set aside soon for people from the audience to ask questions. We have some questions coming in already, and I remind everyone who's joining us, if you are interested in asking questions, send it in. But before we sort of move to that portion of the webinar, I'm wondering if there's, for each of you, if there's one nugget of just information about this case you hope people take away with them from today's conversation to share with their friends around their dinner tables and with their political leaders in their correspondence, what would that be?
Really simply, the climate emergency is real, it's coming, and we have to act together to stop it.
Awesome. Amir?
I'll mention something I said earlier. Around the dinner table, or wherever else you're meeting people, particularly if there are children there, lean across and make sure people understand this. The levels of carbon dioxide that change our climate on this planet are higher than they have been in millions of years. Not since humans began to walk the earth have we been in that situation. This is literally unprecedented, not just to us, but to our entire species. There has never been a human alive on a planet with a more out of kilter environment, at least as far as climate goes, than right now. And so look across that table, look at the children there, and ask and remind others, do you want them to be part of a global experiment with the climate, a way that no other human has ever been in their lifetimes? Because that's what this is about.
Okay, that's a good one. So we have a bit of time set aside for questions, and again, these questions are coming in from people all around the country, and I apologize in advance. I don't know exactly where these are from. So if you're waiting to hear your name, people coming in, that's probably not going to happen. But hopefully you will recognize the tone of the question. So to start out with, we have a question about whether you could tell us what's the core argument being advanced by the three provinces?
Yeah. I can take a shot at that, and Amir, you can fill in. So I certainly don't want to be accused of caricaturing the argument, but I am going to try to encapsulate it succinctly. So in effect, the provinces say that the subject matter covered by this act, by the carbon pricing legislation, really belongs to the class of things that are assigned to them under Section 92 of the Constitution, in particular, property and civil rights. They say that, well, greenhouse gas emissions touch all human activities and really go to the things that it is left to provinces under the Constitution to regulate, and they would not have the room to do what they're constitutionally told they have the sole right to do if this legislation is there. It would sort of muscle them out of their designated constitutional space. And there's no federal power that can occupy it. Okay, I think that encapsulates it, and presumably, you know, we can give you our response to it. But Amir, do you want to add anything to?
No, that's exactly right, Josh. You nailed it. I mean, what the provinces, Alberta, Saskatchewan, Ontario, are arguing is that the matter of greenhouse gas emissions belongs to them. Now, of course, that argument has failed in Saskatchewan's courts. It's failed even more grandiosely in Ontario's court. It only worked in Alberta's court. And for it to work, the Alberta decision had to, and I'm sorry to say this, outright misstate facts. So for example, you read the Alberta decision and it says that there's no impact outside of Alberta of emissions from Alberta. Well, that's of course not true. There aren't invisible glass walls at the border of Alberta and BC that prevent emissions drifting into the neighboring province or drifting around the world. Those glass walls at the borders don't exist. The court in Alberta also said that Alberta's emissions had gone down. Well, that's an alternative fact if there ever was one. The emissions have clearly gone up. In fact, Alberta's own evidence demonstrated emissions went up. So the only way that thus far a court has been willing to accept, to endorse the arguments that Josh just described is by simultaneously making errors of fact and claiming things as true which simply are not. That's part of the reason I'm so optimistic going forward.
Okay. And so we have a great follow-up question to that, which has come in from another person watching. What is the federal government's argument in support of their legislation? In summary, of course.
Sure. So Canada is defending this legislation on the basis of the federal constitutional power known as the Peace, Order, and Good Government, POG for short. It's not just a 90s fad, it's an important constitutional power. And so this has been broken up into different interpretations by courts over the many decades that these sorts of cases have been going up. And there's, I'd say, two main branches of it. There's the POG that comes out of matters of national concern, which Amir alluded to, which are matters that are of not just concern the whole country, but have to be dealt with on a federal level because there's a provincial inability to deal with them province by province. And we say that, well, Canada says that controlling greenhouse gas emissions, or at least putting a minimum price stringency on greenhouse gas emissions, is inherently national concern because no province alone can make that happen. There's a collective action problem. The other side of the POG coin, if you like, is a national emergency. And that's what my client, David Suzuki Foundation, is arguing. So we're saying, yes, it's the same head of power that Canada argues, but it's not just a national concern, it's a national emergency.
Great, thanks for that, Josh. And we have had another question about that national emergency arm of the test, and so it may be appropriate to ask it right now. We have one of our viewers is asking how the national emergency test, if it was the justification for federal action in protecting the environment, what other environmental contexts might it be used in? Yeah, because it's novel, right? The national emergency test in the environmental context.
Yes, that's true. No environmental measure has been upheld under it, although I do note in the Alberta decision, in one of the concurring Alberta decisions, a judge said it might be possible, it's certainly possible, to apply national emergency in an environmental context, but in that judge's view, it would have to be something like the meteor that destroyed the dinosaurs. The bar is set so high that we'd all basically have to be dead before the Parliament could respond to an emergency. So we say, no, that's interpreting it a little too strictly. It can come into effect before that to prevent a mass extinction. Now, the question of what else it might apply to is something that is often asked in the context of, well, is this a slippery slope to sort of dictatorial power? And I understand that, because it is true that emergency powers are sometimes the cloak that draconian legislation comes in. But there are important safeguards under the jurisprudence we've developed for emergency. And one is, there absolutely must be a rational connection, and there has to be on the evidence a rational connection between the emergency and the legislation. You have to show that with evidence. And the law has to be temporary in character. And that doesn't mean it expires when the clock strikes midnight on a certain day. Courts have been very clear about this. It just means that it is tied to some kind of a temporal time stamp. That means there's going to be a chance to reevaluate this. Are the conditions still there? And we say in this case, it's obvious. It's that 10-year window that the legislation is really calibrated to obtain. That is the time to do that check. So what else could be the subject of emergency legislation? The answer is simply anything that can satisfy that test. And I hope there's not too many more of those.
Right.
But what one of them that will be is, if we allow climate change to continue unabated, we'll have an emergency of responding to the impacts. And this is we're trying to avoid. That's what we're trying to avoid now.
Right. Thanks for that, Josh. We have another question that is along the same line of understanding the arguments and the positions before the court. I'm going to read this one out, and maybe Amir, you can handle it, because it's kind of a long question. Okay, so this the question asks, the question to be decided in this case is not the effect of carbon pricing, or the effect that carbon pricing legislation will have on the economy, environment, or First Nations, but rather the question is whether, under the Canadian Constitution, the federal government has the power to enact this legislation, instituting a carbon price throughout the country, even when it is against the will of provincial governments. And I think that's the nub of the question, is what is the thrust of Ecojustice's argument about whether the feds should be allowed to push this forward even against the will of provincial governments?
Well, let me throw two answers at that, Margot. First of all, the premise of the question is wrong. It's just plain untrue. Provinces are not uniformly opposed to this. It is not against all of their will. 3 provinces have chosen to challenge it, but you also have BC actively wading into the case to defend it. So any pretending that there's a clean battle line drawn between the provinces and the federal government is, with all due respect, just wrong. There isn't unanimity there. Further, yes, it is true. The case is not about the desirability of climate action or even the modality of it. The case is about whether the federal government has the power to enact national minimum standards, either for the price of carbon or for climate mitigation more generally. That is true. The case is about those things. But you know what? In other contexts, it has been accepted that the federal government has jurisdiction over interprovincial things that affect the environment. A clear example is if you have a river that flows from one province into the next, and the upstream province could, of course, abuse its position by dumping something into the river, a dangerous substance that drifts downstream and hammers the other province that receives it. In a case like that, it's well established the federal government has jurisdiction to act for the collective environmental good of the country. And it is not simply the right of the polluting province, the one upstream on the river, or the one emitting greenhouse gases into the air we breathe, to decide how it may do so. That monopoly over pollution that the provinces, some of them believe they have, is simply non-existent in our law.
Okay, so I think we have a time for just one last question, and I'm going to make this a two-parter by combining two questions that were sent in by different people, but both I think are very interesting, and they're about the leave to the Supreme Court. So we have a question that asks, and maybe Josh, you could start by answering this, and then we'll give Amir an opportunity to weigh in also. One of our participants is wondering what the different decisions of the lower courts were, like how Alberta was an outlier, and then the sort of overarching question of why you think the Supreme Court granted leave to hear this case.
Mm-hmm.
Why was that? Why did the court think it was necessary to hear it?
So the kind of easy technical answer is that in these kind of situations where you have a reference case directed by a provincial government to its court, leave to the Supreme Court is automatic. These questions are considered so important that the Supreme Court must hear them. But the reason behind that is that, you know, especially in a case like this, we've got three different decisions expressing different views on the question, in some case directly contrary views, and that can't be left unsettled, especially on a question so important as this. So I'm quite sure that even if leave were not automatic to the Supreme Court, they would have granted it, because it's a question that just has to be settled. There was another part to that question, but I forget.
I think that you pretty much got
okay.
Both. What were the and I guess how were the arguments, and maybe Amir, you could explain this. How do we have three different decisions, or at least it looks like two threads here, two courts of appeal saying obviously constitutional, one court of appeal saying obviously unconstitutional? Like, how do we get such disparate decisions with the same piece of legislation?
Well, what happens is, you know, each court brings to this the law, of course, and the evidence, of course. But what also matters is culture. And you can't imagine that an enterprise created by humans, like the law, is somehow devoid of human culture. It isn't. Culture affects the decisions that are considered legal and just at any given moment in history. And I'll give you a clear example. Once upon a time, women weren't, quote unquote, persons able to vote. But then, of course, that was changed in our law. And we would never culturally accept that women aren't persons today. At one point, LGBTQ communities, you know, they were discriminated against. We don't accept that today. Until just a couple of years ago in this country, assisted dying was illegal. Well, now it's legal, and now it's because of a decision of the Supreme Court. Constitutional law particularly has a cultural dimension to it. And I don't want to say anything dark about Alberta, but it does have a different culture where oil and gas is concerned from, say, Ontario. It obviously does. And you cannot expect that the judges on the court come to that high position in society without having been exposed to the culture around them. And they're intelligent, thinking, feeling persons. They will incorporate their life experience and the sentiments of their community into the decision they reach. That's not something that's anathema to the law. Sometimes people say it is. It's actually part of the law. It's part of the way that an enterprise built upon finding wisdom in judgments and finding legal truth in judgments will always operate, because we're not computers, we're humans.
Okay. Well, here's hoping the culture of the Supreme Court is a green one. I'm noting that we are almost at the end of our time, and so I recognize, in particular for you two, that your time is precious this week in preparing. You need to leave time to prepare for these important hearings. So I'm very thankful you had time to join us today, and for everyone who has joined in from their home computers across the country, I'd like to thank you for taking the time out of your day to be part of this conversation. It's great to know that you're engaged in these issues, and that you are standing with the Ecojustice team heading into this important week. Here at Ecojustice, our litigation and our advocacy go hand in hand, and Ecojustice supporters being behind our work really plays a big role in every court victory. Your support is what gets us there. It's obviously what allows us to be able to offer our legal services for free. But almost more importantly, your work is there, your support is there to deliver the real victories. A court victory is never the end of the road. When we win a case, we have to work with governments and mobilize supporters, people like you, to ensure that court wins translate into better laws and meaningful change in our communities and for our climate. And winning this court case at the Supreme Court only really creates the opportunity for continued strong action at the federal level. And we all need to have those conversations with our neighbors and our children and with our legislators and parliamentarians to say this is work that is essential and really needs to be done. Next week's going to be action-packed. The federal government will deliver a new speech from the throne on September 23rd, outlining priorities for the remainder of its mandates. And this is really going to be a litmus test for the federal government's commitment to a green and just recovery. And we will definitely need all your voices to keep the pressure on our elected leaders and ensure they put us on a path to a safer and resilient future. And of course, we'll also have the Supreme Court hearings. So please keep an eye on your inbox for updates on when it's going to go down. In our post-COVID world, Supreme Court Canada hearings are now, well, you could stream them before. Now they've gone the extra mile to ensure people will have access to be able to watch those hearings, as no people from the public will be attending in person. So if you've missed part of today's conversation or you'd like to share it with a friend, we'll be sending you a video link by email. You can also head over to our website, which is www.ecojustice.ca, and we'll have a video up on that site later this week. But in closing, I'd just really like to emphasize that the Ecojustice team is going to keep doing what we've always done. We're going to continue to use the power of the law to defend nature, to combat the climate emergency, and to fight for your right to a healthy environment. So thank you again for joining us this afternoon. Have a wonderful evening. Stay safe and be well.